Good afternoon, everyone. My name is Carrie Damon. I'm Director of Entrepreneurship Education here at MaRS, and I wanted to thank you for coming to this special IP series, which focuses on IP best practices for ICE companies, or ICT plus entertainment and digital companies. We're doing this series in partnership with GOWLINGS, and today we have Henry Ohab from GOWLINGS to speak to you today. I'll do a little bit about Henry's background, and then we'll get on with it. I know we had a bit of a late start. So Henry is an associate and registered U.S. patent attorney in the intellectual property group at Toronto's GOWLINGS Toronto office. He has served as in-house counsel with several high-tech companies in Silicon Valley, including Palm Inc. and Altra Corporation. For those companies and others, he built and managed patent portfolios, enforced patent rights, managed patent demands from competitors and other third parties, and provided patent infringement options. So we'll have a presentation today from about now till maybe about 1 o'clock, and then we'll take Q&A. And just for the video quality, we ask that questions be done through the mic up here. So very warm welcome to Henry, and thank you for coming today.
Thanks, Gary. Welcome, everyone. My practice at GOWLINGS is predominantly U.S. patent law matters, so that's the slant that I'm going to give on the presentation today. And it is very relevant because most Canadian clients, as far as patents go, actually file first in the U.S. since that's the big market. Forms of intellectual property: patent, trademark, industrial design, copyright, and trade secrets. Most of my presentation will be about patent rights, and I'll touch on the rest towards the end. A patent provides the right to exclude others from making, using, and selling a product or a process during the term of the patent, the term typically being 20 years from the date of filing of the application. And a patent is awarded in exchange for a fully enabling disclosure of the best mode of practicing the invention. So what that means is if you've got the invention developed, there might be several different ways of practicing it, or some different ingredients. It's important that you disclose the best way. You can disclose as many as you want. You don't have to really point to it in the application to say this is the best way to do it, but it must be included in the application. Why is that important? Because patents can be invalidated if that's not done, because that really is the essence of the exchange process with the state that you're dealing with. CIPO in Canada, or the US PTO in the US. That's the exchange. You get the right to exclude in return for a fully enabling disclosure. The rationale for that being that at the end of your 20-year period, when you should have gained the full benefit of, your innovation, after that, the society is entitled to gain the benefit, and it's a way to advance the art in the society. Patent rights, territorial, country by country. The closest exception, I guess, would be Europe. That's the closest thing to a regional patent, not fully regional, but the closest. And I'll talk a little bit more about the European filings a bit later in this presentation. So why file for a patent? As innovative companies, I guess one way to look at it is to try and keep things as trade secrets and keep the innovative, the fast-moving advantage over competitors, and that's really a sound approach. But there's a way to take advantage of the patent laws as well, especially when you're working in a new area that's being developed, to build some fences around, which is legally appropriate to do under the patent laws. So it's a competitive advantage to prevent copying by others, so that others don't get a free ride based on the effort and expense that you've put into developing your technology. As blocking patents to market entry, that's a way basically to have, to move towards the goal of owning the playing field if you're practicing in a new innovative area. Down the line, as your technology gets commercialized or there's commercial interest, It'll be very beneficial, of course, to be set up to get a royalty stream, to basically monetize the hard work that you've done, all the innovation. In the case of Silicon Valley, it was very important to attract investment during the dot-com stages in the early 90s. You know, everyone's got stories about how much money was sent their way, right, to start their ventures, and that's true. But the funders in that area were very, very strict on getting patents filed to protect whatever it is that they were funding. Deterring lawsuits from competitors, and of course, closely related to that is if you do get a situation from a competitor where you're held up, maybe because they, I guess, typically they have a patent or a pending application, this is a way to negotiate some cross-licensing agreement for mutual peace, I guess, mutual benefit. And very importantly, although it's the last bullet here, is to increase the value of the company for acquisition, right? Very important, because acquirers, you know, who will be asked to pay top dollar, want to see that they're not buying something that others can easily go elsewhere and replicate and kind of pull the rug out from under their feet. So how do you decide what to patent? The key thing, I guess, is that a patent is a business asset, and the value of the patent will depend on some other factors beyond just the technical merit. So your engineering team, your development team, might be working very hard on a lot of, I guess, you know, technically complex, technically innovative ideas, concepts, but which may deserve a patent. Every one of those may deserve a patent, but there's not, and that's the barrier the United States Patent Office and all patent offices use, that the concept has to be new and useful, right? And you can get a patent. But as a business, it's important to consider more than just the technical merit, right? And not just use the technical standard that the US PTO or Patent Office will impose. So these are some criteria that you can use to try and make the process more objective, the process of selecting which ideas to patent. So basically, if you've got a whole team working and they know they think maybe there's 30 or 40 things worth patenting, but what's you know, going to be the determining factor how many get filed? It's your budget, right? So these bullets here provide kind of a filter so that you can assess the ideas objectively and get the most important ones filed. So how do you decide which ones are most important? The first bullet here is the invention so novel that broad claims are likely to issue. Broad claims might be likely to issue when you're working in a new area, right? How effective is the patent as a blocking patent? How effective will it be to preclude others from copying? Again, if the claims are broad, that's somewhat related. It should be effective as a good blocking patent, but a good blocking patent also has the characteristic that it's not easy to design around. So basically what you do in designing around is look to the claims of a patent and try and, I guess, move away from the subject matter that you think is covered by the claims. And that, of course, when I say that you think is covered, that's typically a legal and technical judgment or project, I should say, not just a technical project that engineers can look at it, at least if they haven't been trained in the patent background as well, or have a patent background. Somewhat related, is it difficult? Yes, difficult for competitors to design around, and designing around then is actually a legally appropriate thing to do. The federal courts in the US have said that it's legally appropriate, and that in itself, in trying to find a way around the patent claims, could itself, and it has, led to innovation on its own, right? So it's an exercise that's encouraged, and it is legally appropriate to do so. The last bullet here, can infringement be easily detected? It's probably the most practical of the considerations here because in the final analysis, if you were to assert your patent against another party, the final arbiter will be the courts. And if you were to go into the courts, typically you're dealing with a judge or a jury. In the U.S. Patents can have subject to jury trials. I don't think this might be the same in Canada. But you're dealing with non-technical people on issues that could be very technical in the patent subject matter, in the patent claims. So the more that you can have things that they can easily relate to, I think the better your case is likely to be. So can infringement be easily detected? If, in the case of a user interface patent, that's what's at issue. User interface patents basically involve things that people can relate to right away. You can see something happening in front of you. So for instance, what's a user interface patent? What's one example? On a Palm type device, like I guess a RIM BlackBerry and a handheld computer. One patent that Palm had to do with when you display the list of calendar events, or actually what you display is the calendar slots, 8, 9, 10, 11 through the day. If you want to be able to read properly the items that are scheduled for the day, well, you tap on a particular location on the screen and you shrink everything that's free, that's got free time, so that only the items, let's say from 2 to 3 you have a meeting, only that shows up, for instance, and then it's readable, right? Of course, it might be 2 or 3 items, not just one item, literally. But the point is that it's easier to read that than if you were trying to display the entire screen from 7 a.m. to 6 p.m. with a time slot for each hour, right? So just as an example, again, that's something that the judge or a jury could relate to. And although it might be not as technically sophisticated or complex as other patents your engineering team might be working on, that to me means it's a powerful patent. Because not to say that you have to go sue and end up in court, but what makes it powerful in court is exactly what's going to make it powerful when you're sitting across the table from your adversary. Because the same things, they're going through the same considerations, basically, that the judge and jury go through in court, and you can, stand a chance of making a more powerful case. So, what's the extreme other case of infringement difficult to detect? Well, I guess an obvious case might be in a complex integrated circuit device, where, let's say you suspect the competitor might be infringing this one patent of yours. But of course, what they ship is an integrated circuit that's very complex. There isn't enough information available from the marketing materials to see if your patent concept is being used, but there are ways to reverse engineer the patent and get to that, right? In which case you'd have to use a specialized reverse engineering outfit, and they have the specialized equipment, and basically end up with maybe some circuit diagrams and timing diagrams, things like that. So your case may still be as strong as in the user interface case, but now you're dealing in an area in which non-technical people, right, like maybe a judge or a jury, not to be disparaging at all, but it is a factor that maybe, their eyes might glaze over when you start to get into all the details of why the competitor infringes, and you're putting up timing diagrams and circuit diagrams that they're just not accustomed to dealing with. So just as the other extreme example, now it doesn't mean to say that if you've got a concept that operates at that level that you shy away from it. No, because all of these bullets are things you consider. You don't need to score high on the highest on every one, but it's basically some things that you want to go through to make the process more objective to select the ideas for patenting. Where to file? Value is increased if protection is obtained in multiple jurisdictions, meaning multiple countries. Market where's the market for the product? Understand that you've got a 20-year term, of course. So there are, and I think it's somewhat similar from country to country. The terms actually vary, but it's in that region for a patent. And it's important to consider not just market acceptance or market revenue today or next year, but think 5 years out into the future, right? Where do you expect your revenue to come from? Because these are things you need to anticipate. Because from the time you file that first application, what's called the originating application, you've got a limited amount of time, and I'm going to go into those timelines a little bit later, to file in other countries. So if you miss that boat, right, and 5 years from now, one of those countries end up being a big source of revenue, you've missed it. So you think growing economies as well. Consider that in deciding where to file. Also, where's the product going to be manufactured? That might be a way to possibly nip things in the bud if knockoffs will come from that manufactured source. Where are the competitors? Where's the R&D market? And practically speaking, which jurisdictions are strong in enforcing patent rights? Consider not only just the jurisdictions that are strong today, but which jurisdictions are genuinely interested in improving enforcement of patent rights. I think compared to maybe 5 years ago, China's very different now, I would say, compared to 5 years ago at least. So take that into account as well, and don't just let the lax enforcement maybe today. Don't just decide based on that. Is it difficult to predict? Yes, but again, it's important to go through the considerations, I think, to make the best decision. Okay, what's involved in preparing the patent application? Well, the inventor interview, so that the practitioner who's going to prepare the patent application can get the enabling details, including best mode that I mentioned earlier. Then there's the patent application to be drafted, after which it'll come back to the inventors for a final review, sometimes more than one reviews, and get them to basically sign some paperwork, maybe a declaration that they're the true inventors, an assignment that if they assign it to their companies, their employers, and a couple of other ancillary things. And prosecution of the application. From the time an application is filed in the US Patent Office, it might be 18 months, 2 years before you get the first office action, when they basically write saying, no, we're rejecting all the claims because, and then they'll cite the prior art, or sometimes claims might be allowed on the first action. But that's the timeline, and in the case of software patents, it's probably 2.5 years. But over the last year, surprisingly, it has been coming down, and that's been the stated effort there at the patent office, at least from the, I guess, the director level, that's what they want to focus on. So the prosecution stage, typically there's 2 rounds with the patent office, and hopefully a patent will come from that. But there's also ways to extend that so you don't end up being totally out of luck after the 2 rounds. Inventor interview, actually, let's see. Yes, at the inventor interview, it's important to have the inventors, I guess, aware. They have to be able to get the information to talk about some of these things. Public disclosure, has there been any public disclosure of the concept? And I think in the next slide I'll talk about bars to patenting, but that might have triggered, a public disclosure will typically trigger a bar to patenting. Doesn't mean it's an absolute bar. In Europe, yes, in a lot of countries it's an absolute bar, but in the US and Canada there's a 1-year grace period. And it is a bar once you use up that 1-year grace period, an absolute bar. Determining inventorship. It's important to determine correct inventorship for the application, and correct inventorship is determined based on the claims of the application. So not necessarily who worked on the project or projects or whatever else the specification, the entire application may describe, but it all comes down to the claims, right? So anyone who contributed to the subject matter of any one claim, not most of the claims, not the main claim, any one of the claims must be named as an inventor. And there's many cases in, I guess, in litigation history, I should say, where patents have been invalidated for not naming the correct inventors. Now, I have to say, practically speaking, in common cases where you have a large number of people working on a big project, it might not be absolutely, there's no absolute perfect way of cutting it, of determining who's the inventor from not. But I think it's important to to make a diligent inquiry and undergo a diligent effort to determine right inventorship. And that shouldn't be overturned, that'll stand, right? But when there's evidence that inventors were named based on rewarding people who worked on the project, things like that, and again, assuming they didn't contribute to the claims, right, then patents can be invalidated on those bases. So the USPTO is very strict on getting inventorship right. And of course, the last bullet on here, it's important for the practitioner to understand the invention during the inventor interview. And basically, as in-house counsel, that's one of the things I was strict about. That's where the practitioner has, let's say, half an hour, 1 hour with the inventors, and that's where they need to fully come away with everything they need to write the invention. Because typically, those inventors, when they go back to their desks, they're very busy people. They're trying to get new products out. They're very pushed in terms of schedules. So, we don't want to have them disturb, minimal disturbances. So it should be in a very rare occasion that the practitioner has to come back and bother the inventor for something else. Of course, the inventor will get a chance to review the application. In fact, must review it before it's filed. Bars to patenting, I mentioned. So public disclosure, public use of the invention, or an offer for sale may be a bar to obtaining a patent. And now, having said that, the things on the first bullet, in the US and Canada, and a couple of other countries that don't come to mind, but only a couple of other countries, there's the 1 year grace period for patenting. As I mentioned, Europe and most jurisdictions require absolute novelty. So keep in mind then that if you use any part of that 1 year grace period given by the US and Canada, if you're into that, you can still file in the US and Canada, but you can no longer file in Europe because that absolute bar still applies, right? So, another point, an important point I'll make later is about filing early, but that's what's important about filing early before you take a lot of undergo a lot of public action, public effort related to the application, or to the invention, file it. So any of the bar actions will start the clock ticking. Of course, I know one thing you might be thinking when we talk about public disclosure, public use, or offering is, well, you don't know how you're going to complete this invention sometimes because you want to bounce it off your customers or prospective customers, right? So that what you're patenting is, and there might be several inventions, is the right one, but you need some customer input, you need some feedback. Well, the answer to that, which keeps you away from that category of public disclosure, is to use non-disclosure agreements, right? With an appropriate description as to what's being disclosed and get the other party to sign, really. But, that's as opposed to a public disclosure at a trade show or something like that, where anyone who walks into your booth, gets the lowdown on the invention. So using non-disclosure agreements also avoids the potential for the other party filing for a patent on the same or similar ideas. On its face, that seems like someone's looked to rip you off, but in my experience, not necessarily the case. Because when smaller companies talk to bigger companies, a lot of times it's because why the bigger company is interested in what you're doing is because they have people working on things like that or in related areas. And you'd be surprised how things naturally can get, filtered and crossed the wrong way, and doubts can arise, right? And, rightful controversies sometimes. So the way to avoid that is, again, to use the non-disclosure agreement, especially if you're trying to get a party, but a bigger party really, with more power, interested in your technology so that maybe they could license it or use it. And typically they have the superior bargaining power then. So that's where this NDA should be used. It should be useful to you. And file a patent application early, I mentioned that as well, so that you can preserve rights in all jurisdictions, not just US and Canada. Determining inventorship, as I mentioned, the key issue is who contributed to the subject matter of the claims. So not necessarily the entire description of the application when you read it. Sometimes an entire description can actually contain several inventions, right? And if that's the case, and it's not infrequent at all, once you file it to the patent office, the examiner will require a restriction. What they'll tell you is there's 3 inventions here or 2 inventions. You're required to elect claims 1 to 5 and 7 to 17, right? Meaning the other claims are directed to the other inventions. And that's when you have to select which way to go. But the point is, it doesn't mean that you abandon what they see as the other inventions. You have a chance to file different claims on those. But again, it comes down to the claims. What's the relationship of the inventor with the company? An employee or a contractor? Typically, if it's a contractor and you don't have an agreement done beforehand as to who's going to own the IP rights, or that they're within the scope of the contractor agreement, as part of what they're being paid for, that they agree to assign all rights in the invention to the company. Not in every case that's justified or that'll be agreed to, but the key thing is to have that agreement worked out ahead of time, because if you don't, and that contractor is an inventor and rightfully named on the invention, then without an agreement, there can be some significant issues of ownership that develop, right? And they can end up with joint ownership of the patent. And at least in US patent law, every joint owner is entitled to do with it as he or she see fit. So you don't necessarily need the consent of the co-owner. That rule differs. There's that exception. The exception to that rule might have to do with bringing suit on the patent, right? So not absolute what I say, but the point is that one way a competitor can get to you is go license your patent from that other guy, right? The contractor who co-developed it with you. He is a co-owner, right? And he's entitled to license it full rights, just as you would be. Now, if he does that, there might be some recourse that you have civil recourse, accounting for profits. But why go through the door, right? Very expensive and time-consuming. So let's see. When was the invention created? Joint inventors, as I mentioned, anyone who contributed to at least one claim, any one claim of the patent. And as I mentioned, naming correct inventors is important. You don't want in litigation that your patent ends up being held invalid or unenforceable. Kind of related, but slightly different things. And it's common in patent litigation for those defenses to be brought up, right? Rest assured that in patent litigation, every avenue of defense will be explored thoroughly. So you don't want to have to kind of give the adversary this one to play with. Ownership, increased value when the patent is owned by a single entity. So one case, as I mentioned, was the contractor case, right? In which a competitor, or maybe not even a competitor, a third party that's interested in licensing the patent, and you quote them price. What if they can get it for half the price from the contractor? How about, this is where it gets more complex even in the contractor case, how about a joint technology development where typically 2 companies of equal standing might work to co-develop technology, right? The same thing applies. And you've got a party now that's not maybe a smaller contractor that, it might be easy to bring them to an agreement, but you've got a significant other presence, the equivalent of maybe yours, to deal with. As I mentioned, ensuring employment agreements are in place before the IP is actually generated. That assignment agreements are in place before research is done by any third party on your behalf. And the same goes with regard to joint collaborations, joint development of technology, as I mentioned. It would be important to discuss and conclude some agreement as to who's going to own what, right? Let's say, you know, two companies work to co-develop something. It's important to work that out between themselves first. Again, if inventors are on both sides for both companies, all of those inventors must be rightly named. But ownership is a different issue than inventorship. And any ownership agreement or arrangement can be worked out. It can be agreed to that one company, this one company will own all of it, or this one company will own all of it. But it's important to have that done beforehand, or else it's more difficult and more controversial to do it after the fact. Prior art searching, this question comes up quite a lot, actually. There's no duty to search for prior art, at least with regard to the US law, but you must disclose prior art that you're aware of, relevant prior art, I should say. And that doesn't mean swamping the patent office with maybe 30 documents or something like that. You'll be held to the standard of which ones are relevant, should you have reasonably thought were relevant, and that's what you must put before the patent office. Searching patent publications, if you're going to do a search, sometimes some cursory search is necessary, even advisable. And big companies especially have to watch out for this, that it might have implications related to willful infringement for any patents found. So for instance, you're doing your search, things are going to come up of competitors' patents working in the area you're working in. So if it's shown that, if you're ever found to be infringing one of those patents, being aware of the patent is when you're considered on notice of the patent, and that's when damages can start to accrue. Not only that, but with actual notice of the patent, you might be liable for enhanced damages, what's called willful damages, typically 2 to 3 times the assessed damages, because then it'll be held to be willful infringement because you are aware of the patent, right? Maybe you didn't even investigate it, you didn't copy it, you just found it while searching. Well, the organization was on notice then because you're aware of it, right? You might be thinking, well, if you just search and you find it, however will it come out in litigation that you knew about this? But, electronic discovery, amazing things happen with electronic discovery. So don't ever think that, maybe because you didn't pay attention to it, that'll be, enough of a barrier, I guess. So with regard to that second bullet again, must disclose relevant prior art of which you're aware. Keep in mind that duty starts from the time you file the application all through to when the application is, let's say it's issued as a patent. So that duty is continuing throughout the entire period. So if you don't know of something relevant today, but 2 years from now when the application is still pending, you become aware of it, you're under the duty still to notify the examiner, to bring it to the attention of the examiner. So drafting the patent application, it's important for the practitioner to understand the invention I mentioned technically, and it always helps for the practitioner to understand the client's commercial context. Who are the competitors? What's the competitive landscape like out there? Who owns other patents, the types of things like that, what competitors? To prepare sufficient and enabling disclosure, and maybe we shouldn't say do not characterize the prior art, but avoid characterizing the prior art. The reason for that is that in litigation, it has been held in more than one cases, so it's not like an obscure rule, that a lot of the times when you criticize the prior art, you actually are doing so within the context of what you're doing. And that can actually count as characterizing your case and how it's different from the prior art. Many times it's been held like that. Not unreasonable in my view, at least. So there's a way to file your invention and emphasize the usefulness and benefits and craft claims properly without having to unnecessarily knock the prior art. Claims of varying scope, so broad claim, intermediate claim, narrow claims with dependent claims to them all. Reason being that in a situation where prior art that the patent office or you didn't find when you were crafting the application, if relevant prior art is found before, what the silver bullet type prior art, the first of all will be your broadest claims, very likely. So if that happens, that's when that kind of defense in depth, broad, intermediate, narrow, comes into play. That even if your broad claims were to be held invalid because of prior art that wasn't considered during prosecution, at least your narrower claims, you have some recourse left. And narrow doesn't mean less valuable necessarily, because if the narrow claims that are left exactly read on what the competitor or adversary is doing, those narrow claims could still be useful. But it is true that generally the broader claims tend to be the more valuable claims. So claims of varying scope, less vulnerable to prior art during prosecution and in litigation. Claims of the issued patent define the legally enforceable scope of patent rights. And of course, it's important to draft different types of claims. Claims directed to a product, right, like a handheld computer. Claims directed to a system that the handheld computer is used in, maybe a wireless network, including certain specialized servers, for instance. And the method. So the method, for instance, should ideally relate to not just practicing the method on a handheld device, but on any computing device, right? So that's why it's important to consider all different variations of claims. U.S. provisional application, consider filing only if a public disclosure is imminent and it's not something that was maybe anticipated or something almost like an accident happened and you didn't file it or send this thing in for preparation and filing on time. Only then, I would say, is it recommended to file a provisional. Why do people file provisionals then? Because it's less expensive. Provisions really don't require claims necessarily. So a lot of people over the years have fallen in the trap of, let's take everything related to the project, which you're allowed to do, within reason, of course. I mean, like binders, but certainly maybe one binder describing the concept. And we'll put that in and file it as a provisional. That's allowed. The problem is that eventually for the patent to be examined, you have to convert it into a regular utility patent. And when you do that, it's time to write claims. And lo and behold, if you write claims and they're not supported within the original disclosure, they'll be rejected for that reason, right? So, as in-house counsel, for instance, I had a rule against provisionals. There will always be an exception, of course, like this thing's really important, somehow it missed the filtering process, but yet someone in marketing needs to talk about it tomorrow at the trade show or whatever, something like that, let's say. Very extreme, very rare case, yes. But other than that, don't use it as a practice. The savings up front, the little savings up front, doesn't justify the risk of having an application in which the claims to the invention you want can't be supported in the original spec. Sure, the spec talks about it generally, but when you craft the claims, that's when you start to think about the invention, right? And the invention isn't everything I've said, is, what that's in the spec. It's very directed and hopefully supported by the spec. So it's important, I think, for the practitioner to actually go through that effort and think about what is the invention and what it is that you want to protect, right? Because the claims are, what the courts in the US have called, they define the metes and bounds of what the patentee owns. It's like a fence around the property. That's what you own. And when you go into court, it's important to be able to spell out clearly what it is that you're asserting, what it is that you own. So the risk with the provisional is that even though you've put in so much material, you might still find aspects of the claim that you want that really are not enabled or disclosed there. or maybe the best motivate. So that's the downside of provisionals. Patent cooperation treaty application. So this is important with regard to filing in multiple jurisdictions, for instance. It's an international application that holds a filing date in nearly every country in the world. Not all countries, but most countries in the world. And how do you file a PCT application? You can file a PCT application as an originating application, or you don't have to. You can file a patent application in any one of the member countries, and you have a year within which to file your PCT. So for instance, you file a Canadian patent application, you have a year, to take it around the world. So before the year ends, you must file the PCT application. Now, if you know exactly which other countries you want to go into, and it's not really the rest of the world, it's maybe the US and Japan, for instance, go directly, you have a year, go directly to the countries. But if you want a holding pattern, right, you file the PCT, because the PCT gives you additional time to select which of those countries, member countries, you want to go into. And I think I have a little chart about the exact timelines a bit later. Anyway, there it is, 30-month deadline for selecting jurisdictions in which to obtain protection. So that's 30 months from the original date of filing, right? Whether you file the originating application in a particular country or as a PCT. When you file it as a PCT, there are PCT receiving offices in many patent jurisdictions. So for instance, in Canada, there's a PCT receiving office in Canada, there's one in the US, etc. So what you would do is to file not a Canadian national application, but a PCT application, but you file it in Canada, right? And of course, you get a patentability report in a much shorter time than, for instance, the US PTO does the search. That's an initial patentability report. It gives you a chance to see what prior art they've found and whether you want to amend the claims, or if you think you have good arguments as to why the references don't disclose the invention that you're trying to patent. A European application is closest to a regional patent, and it's a single examination process for EU member countries. And once you go through that single examination process, and if it goes to grant, the equivalent term in the US is issuance, then you're allowed to select particular countries for the patent to be validated in which case in those countries the patent will issue. First filing, I mentioned typically because of market considerations, Canadian may file in the US first. Provisional, lower fees to preserve a priority date, and that's important actually. Once you file a provisional, you have 1 year to convert it into a regular application with claims to be examined. What if you don't? Then your invention goes abandoned, right? So you've got that 1 year. Once you file a provisional as well, remember it doesn't get into the examination queue, right? It just buys you a year to file your regular application. And once you've converted to a regular utility, then it gets into the examination queue. Let's see, Canada doesn't have a provisional system, by the way, but most countries will respect the priority date that you can get by filing a provisional in the US. So the spec of the provisional application must support the claims once converted. File early to take advantage of the presumption that the first to file is the real inventor and entitled to the invention, right? There's a process, let's say, where the same invention is filed on by different people. There's a process in the US called an interference process, by which they attempt to determine who was the first to invent. In so many countries in the world, first to file gets the invention. In Canada, that's the case. In Europe, that's the case. First to file. So especially if you're in an area in which there is active competition and people are patenting, file first. Prosecution in the US, a well-prepared specification and claims can make the prosecution cleaner. Cleaner meaning less of an incriminating I use the word loosely, incriminating trail. What do I mean by incriminating? In the US, there's this concept of file wrapper estoppel. And in litigation, it could come out that in prosecution of the application, before issuance of your patent, that in order to get it, you argued before the examiner, well, that's not what we're doing, this is what we're doing, and that's how come we're different than what the prior art is doing, right? You'll be held. You can't contradict those assertions you've made and the stance you've taken. In litigation, you can't contradict, meaning that you can't say, well, our claims are not limited to that, they're as broad as this. File wrapper estoppel, that's what it's called, right? That doesn't exist in Canada. So yeah, once a patent issues, you'll have a lot more leeway with the claims. But there certainly merit the file wrapper estoppel system, I guess. I mentioned that the duty of candor applies during entire pendency of the application. Maneuverability. You actually have quite a bit of maneuverability with regard to pending applications. The key thing to remember, though, is that however you want to amend claims, let's say a competitors come out with a product, and maybe the claims as filed don't exactly read on the product. There's one step that maybe isn't really in the claims, right? But you've also got that in the specification of the application. You're now allowed to amend claims so that they read on what the competitor is doing, right? The restriction being that you're not just allowed to amend claims anywhere you like to cover the product that you want to bring under the infringement umbrella, but it's limited by the scope of the specification that you filed in the application. So for instance, a simple example, if you were talking about the red wagon in the specification, you can't amend your claims to say yellow wagon, for instance, right? So that's the limitation, but otherwise, with a well-prepared specification, there should be good opportunity for amending claims. And why would you want to amend claims then? Well, so that they read on the accused products, in which case, you might not have to wait. It'll be a business decision. Do you want to wait for the patent to issue? Or do you want to go talk to the infringing third party right now and try to get them to take a license? All options are open. Because as a patentee, you have patent pending rights. You can't bring suit on it, but you do have patent pending rights. Okay. And amending the claims of an allowed patent, very much more restricted than compared to during the prosecution of the application. Post-filing timeline. So once the original application is filed, then this is the timeline for the different activities. So I think this slide could be approved because one way to interpret it is that the 18 months is an addition to the 12 months. I mean, that can be clear. That's not the case. All of these numbers are measured from the date the originating application was filed, okay? So from the time you file an application, let's say in the US, and you decide that you want to go possibly in more countries worldwide with it, you have 12 months to file your PCT. Or again, if you know that you want to go into 3 countries only then, you have that same 1 year to go into those 3 countries. Keep in mind that after you file an application, 18 months after, it's published in the US, in Canada, in Europe, in probably many other jurisdictions as well. 18 months after the filing date, it's published, so it becomes public. And 30 months after the original application is filed, that's when you have to elect which countries worldwide do you want to go into. So it's called national phase entry of the PCT application. There are some ways to actually extend that to 42 months, but that's the general rule, 30 months. Post-filing strategy, we talked about a timeline for selecting jurisdictions, and keep in mind that that delay that you buy, the time that you buy when you file a PCT, could allow time for funding, because you can maybe afford to file in one jurisdiction, but certainly not worldwide, which can get very expensive, especially as prosecution advances. So you've got time to secure funding to confirm market acceptance is this the invention that you really want to go worldwide with, or is it another one? What's accepted by the market? What's going to make more revenue for the organization? Especially important in the case of life sciences, I guess. You might want to wait for some research and test results as well. And allows time to, I guess, gather partners for whatever business exploitation you want to undertake for the invention. Some U.S. considerations. Continuation practice in the U.S. is, I guess, different than in Canada and in Europe, where there isn't a continuation practice. What continuation practice means is that once you obtain allowed claims, so you've argued back and forth with the examiner, you've amended your claims, and so he says, these claims are allowable because the prior art doesn't disclose this subject matter. You're allowed to let that patent issue with your allowed claims and file a continuation patent that's directed to broader claim scope, right? Now, the broader claim scope, you can try to go back and maybe recapture some of what you gave up during arguments before, but now you're going to have those same arguments maybe you made held against you. But there's a lot of gray area in between, maybe what you surrendered and what has issued right now. So in many cases, if you think this patent applies to an active area of commerce, it's worthwhile to keep that continuation going. If nothing else, the case of amending claims to read more exactly in a competitor's product supply. And that's actually, in my opinion, the most valuable way that continuation practice has been used. Because you can more get a party, an adversary's attention or bring them to the negotiating table once you have claims that read exactly on, ideally, the big product revenue, the big product revenue generator that they're shipping. So that's the benefit of filing continuation. Again, it's not a free ride, right, that you're allowed to craft claims however you like, because that continuation, the continuation claims must still be supported under the original specification that you filed, right? So that's the limitation on how wild you can go with continuation claims. Terminal disclaimers, double patenting. There are cases where you file a continuation if the examiner finds that some claims are pretty much the same as what issued before. So he's not going to allow maybe the ones that you've worded differently. There's a way to do something called a terminal disclaimer, which is to say that you're disclaiming the rest of the term over the original patent to get the slightly larger scope claims or differently worded claims issued over your original patent, because your original patent, in that case, is cited as prior art for the claims that you want to get in the continuation. For improvements to your invention, such as for different product improvements, continuation in part applications can apply, in which the subject matter is essentially the same as maybe what you filed in the parent case, in the originating case, but there's a different twist to it now. So continuation in part application allows you to capture maybe that incremental improvement or advancement. Okay, so that's it for patents. So I'll just talk a little bit about trademark, copyrights, trade secrets, and industrial designs. So trademark, a word, symbol, design, or any combination thereof that's used to identify the origin of goods. Because that origin of goods is tied to a customer's expectation of quality associated with it, and the goodwill possibly that the customer has come to associate with that mark, word, or symbol. So the standard for infringement is how likely are consumers to be confused if you come out with a mark that's similar to Coca-Cola, for instance. And that'll be the standard. Are consumers likely to be confused and pick up your product instead of the real Coke or something like that? That's basically what the court goes through to analyze infringement in the case of a trademark. Actual use. So if you haven't filed a trademark registration, but you're actually shipping your product with a nice, catchy name or mark to it, or symbol, logo to it, Actual use does establish some rights under common law. But if there have been prior registrations may result in infringement of the rights of others outside your limited geographical area. So when you depend on those common law rights just from actual use, you haven't registered, then you're limited. You're more limited in terms of geographical scope. Have a trademark search done before investing in a particular name or design, very different from the patent case. Trademark period for 15 years, renewable indefinitely. Typically, the main barrier to renewing it is that it's actually being used. Again, the slant in this is, I guess, US trademark law, but I dare say that Canadian law is somewhat similar, goes in parallel somewhat. Copyright. Copyright vests with the author of the work. Copyright, of course, protects the expression, not the underlying functionality. And software, actual software, is protected by copyright. The algorithm for the software might be the subject of a patent, right? Or patent filing, but the actual software itself, just as it's expressed, the statements, that's actually protected by copyright. So copyright prevents copying, not independent creation. And I know the thought is, well, they could be the same thing. Well, that's what the court will have to determine, if it was independent creation or not. And if you've copied things with maybe some modifications, and to you, it looks pretty good as an independent creation, well, guess what? The court might come to a different decision. That's the risk you take, right? The term, 50 years in Canada, 70 years in the US. Actually, I should say, I don't know if the Canadian laws have changed recently. Could be the case, but it was changed probably maybe 10 years ago or so, maybe less than that, in the US, from 50 years to 70 years. And the fee for registering copyright is actually quite nominal. Registration allows damages for infringement. So, in the case of software, if you've shipped your software product, but you haven't registered it, but lo and behold, you find one module of software being reproduced and used elsewhere. It's actually happened, not frequently, but not infrequently. You're not totally out of luck because you can still file suit because you have rights as the original creator as long as you can prove that, and registration helps you prove that, but you're without registration, but there are other ways to prove it. And you can go to court and win, but if you win in a situation like that, all you get is like nominal relief, right? To actually get damages, you must register. But once you find out infringement, in a copyright case, you can actually go register it at that late date. But you do want to register it because that's when you get monetary damages, other than nominal. Yes?
Hi, sorry to interrupt. I have a question about the previous slide.
Sure.
Oh, sorry.
Yeah. Okay. Yeah.
Sorry about that.
No
I'll be
problem.
brief with my question. It's actually referring to trademarks.
Trademarks, okay.
Is there any system sort of comparable to the patent system of sort of laying things open and sort of letting the world know that you intend to trademark something and allowing people to comment or oppose it?
Right. Good question. I think in a lot of cases, yes, in the US, for instance, there is a trademark opposition process. Right? Unfortunately, I'm not sure about the situation in Canada, but in the US there is. Just like in Europe, just to go back to patents briefly, in Europe, before patent issues, there's a process for opposing it, or there's opportunity for opposing it. There's a process for that. In the US, there isn't for patents, but in the US, there's that process for trademarks. Right? And typically, what big companies will do is have standing searches on their competitors, so you can see what's being published by the trademark office, that this is being proposed for grant as a trademark. So it's typically given to the public like that. Once the trademark examiner has decided, yes, it doesn't infringe on anything else, you deserve a trademark, then they put it out there to see, let the public have its shots at it. So infringement of copyright, any unauthorized copying, distribution, performance, or display of a work. Industrial designs. I guess, analogous thing in the US would be a design patent that covers not the functional aspects that the regulatory utility patent covers, but it covers only ornamental design, right? Non-functional things. That's design patent in the US and industrial design in Canada and in Europe as well. Covers the shape, configuration, and ornamentation of an article, not functional. And in fact, there's been cases in the US where things have been done to get a design patent, let's say, but yet, kind of through the back door, some functional aspect was put in there, right? Because the design patent will still be enforceable. But if it's found that any aspect of it, of the design, the ornamental design was intended to cover functional aspects, your design patent can be invalidated. Typically it'll happen in litigation. The patent office doesn't go looking for reasons to invalidate once they issue something. There'll have to be some controversy that comes up. Okay, typically useful for consumer products of high volume that may be subject to foreign knockoffs. So still valuable. Relatively cheap to file a design patent compared to utility patent, but does provide more limited protection. And I guess in Canada, the protection period is 10 years. I think it's the same in the US.
Question with regard to design.
Could you use the mic? Yeah.
In patents, you have patent pending. Is there
Right.
such a thing for industrial design, or do you have to wait until it officially comes?
No. In the US, yes, there is design patent pending, for which you would use just patent pending, but it would be for design patent. For industrial designs in Canada, I don't know.
But there is in the U.S.
There is in the US.
And if
Correct.
you do an industrial design, are you better off doing something in the States first and then doing it in the countries that will tend to knock off? Or,
Interesting, yeah.
or am I better off doing it in the knockoff countries and then?
I would
Which
go, yeah, this is like from the gut, maybe not properly, fully thought through, but I would tend to go with filing in where my main market is first, right?
in the US.
Yes, and if that is your main market.
Yes.
And then within that time period, and keep in mind that in this case of design patents, that time period for filing elsewhere is 6 months, right? It's not 1 year, right? So within that 6 months, try to, decide which countries knockoffs are likely to come from and file there.
Is there an advantage, though, to actually file on the identical day? One person said that if you're doing it in Canada and the States, you're better off doing it on the identical day as opposed to because you're slowing down the process. I'm just
Right. The only benefit to that, right, would be once you file in the country, let's say you're first filing in the US, why would you file in Canada the same day? Well, to advance prosecution. Because remember, until you file in the country, you don't get in the pipeline for examination. So I would say the only advantage, right, would be that you get in the examination queue. Because I think in Canada, the times to examine are even longer than in the US. And it depends on when you elect examination as well.
And
So that would be the one advantage, but otherwise, no. And it's a good way of deferring costs. So you file your first filing, and within the year, you can file in other countries. But yes, if you want to have a patent issue fast in those countries, then yeah, go the same day. Now, I should mention, with the patent prosecution highway that's established between some, I guess, top 5 patent offices, Europe, US, Canada, Japan, and I forget where else. There's a way to advance your examination in those countries by taking advantage of some of the work that's been done in one of the cooperating patent offices. So I don't exactly cover that here because that's all in the pilot phase right now. The laws are not fully established yet, but there are some ways, better ways I would say, to advance examination than looking to do that.
okay, I have another question, but I'll ask it after.
Okay. Trade secrets can be anything the company considers valuable and has not made publicly known. And that means you must take active steps so that it's not publicly known. customer lists, product plans, formulas for products that you're making, items that you're making, even details of manufacturing process, 3M post-it notes. A few years ago, as you know, the company I was at, we were looking at some similar things. Can't remember the exact context, but 3M really never filed for patents on that. They kept those trade secret mainly, I guess. The thing is, though, that every product that you might think might be a good alternative, a cheaper alternative to the 3M products that I found, they never work anywhere as near as good as the original. So obviously a case, I think, in which the trade secret protection has worked very effectively for them. One advantage, I should say, though, in this case that I'm talking about, the manufacturing process case, is that keep in mind that the manufacturing process only happens within the company. If you're shipping a handheld digital computer with a nice feature that you would like to keep a trade secret, well, guess what? Unless if it can be reverse engineered, people are going to find out about it, right? So that's why it would make sense in maybe in a manufacturing process situation. You'd have more control over it, and it can't be reverse engineered easily, right? You've got to take reasonable measures to protect confidentiality, and sometimes that bar can be quite high, really. The standards can be quite high, because once that disclosure happens, your recourse is typically against the person, the organization that has made that unauthorized disclosure. But for people who are using it after that, probably more limited recourse against them. So once disclosed, protection is lost. And that's it. Questions? Mike? Just the mic, please? Yeah.
We have a lot of research grants going through universities, Ryerson, University of Toronto, et cetera, where we're a company and we've put up a small amount of money for the research institution to be able to get a much larger amount of money from a granting body. In those cases, what is the best IP structure to negotiate? I know it varies depending on the research institution. U of T is institution-owned IP, whereas
Right.
Ryerson is inventor-owned. So particularly in a case like U of T, what would be an ideal negotiation for the
On
IP?
behalf of the U of T?
For the IP that would have been generated
Right,
from
so
the
you-
research project.
Okay, so you're partnering with them, right? Because I asked because there's three parties here. There's the party, the government really of Ontario probably, that's giving the funds. There's U of T, and there's the outfit that's partnering with U of T. So which side do you want me to look at it from?
So we're the company
That's partnering with U of T,
that's
right?
partnering
Yeah.
with U of T. We've written a
Right.
grant, say, through OCE, where
Sure.
the lab gets $25,000 to work on a specific problem.
Right, right.
And then we have to negotiate who owns that IP at the end of it.
Right, right. So I think this is a situation in which any variation that you can think of as to who owns the IP can be worked out, that the U of T can own all of it, you can own all of it, or maybe split it some way. The key thing then is to agree beforehand, before the research is done, because your options are more limited once the work is underway. And once the work is underway, the other party tends to see it as if you're trying to take advantage, get some leverage over their position. So I think what you've got to do is look at their standard terms. I'm assuming that they might add some standard terms right now for how they handle this kind of joint collaboration research, and come up with some arguments for negotiation as to why it might be more appropriate for you to own more of it in this case as compared to their blanket policy. So it's got to be done on a negotiation basis like that, I think.
Can you offer some, I don't know if you've worked on cases with specific examples like this. Can you offer some insight as to what typical situations end up looking like?
Right. Yeah. On a limited basis, I've worked with them. I do know that a lot of the major universities in the U.S. have very, very strict and more onerous terms than U of T, for instance, or than the Canadian universities do. So that's it, generally. So again, it's got to be done maybe on an individual basis, and basically trying to convince them why, their terms can't work in this case, why it's too onerous, and why you, as the collaborating party, deserve more. You're more likely to have success with those arguments when done early enough than later. That's what I would say. So try and address that very early with them. And that's your highest chances of, I think, success in getting something better than what their standard policy is. Sure.
Hi, so I've just got a very practical question, and I'm sorry, you may have already touched this at the beginning of your presentation, but what are the cost implications of maintaining a patent and maintaining a trademark as well?
So maintaining a trademark, I guess the easy one first. I don't think that it's unduly expensive. The main thing is maybe every 5 years, I believe, you've got to show that it's still in use, right? And then some renewal fees apply. In the case of a patent, renewal fees are typically every other year, and you do want to have tabs kept on when that renewal fee is due. Whether you use maybe some specialized firms that do that, they have the docketing systems, or whether you do it, you don't want to miss those dates, because it's almost like you're under the gun to prove afterwards that you couldn't have helped it. That's why you missed. And then what happens if you don't meet that high standard? You lose rights to your patent. Right, so yes, patent renewals can be more expensive, so I would think maybe a couple thousand or so every one of those every other year renewals that come up. So yes, there's that expense as well, even when you have a patent throughout the term. I'll leave it at that, yeah.
Hi, I wanted to ask about financial product innovation. Like, what would be the best way to go about trying to secure your idea?
Right, financial product innovation. So this brings us to a very hot topic in IP, I guess, systems now, or jurisdictions like Canada and the US. It's possible to get patent protection for financial system innovations, right? But the thing is, generally, it mustn't be tied to just automating a process that exists right now. It mustn't simply be an automation of manual processes that exist right now. So there must be real innovation in it. And within that real innovation, it's important for it to be presented by the practitioner in the right frame. The right frame meaning that there's got to be appropriate hardware architectures as to this system that you're proposing having, let's say, a tangible effect on something, right? A tangible effect on an output. So that's generally how it's got to be framed, but yes, it's possible. And very recently, of course, the US patent system, meaning all the way up to the federal courts, to the Supreme Court even, have validated that, yes, this is something that that will be protected by patent law. Question? I know it's a small room, and we can probably hear each other without the mic, but since we're recording, that's why we're...
Henry, thank you for the presentation.
Certainly. My pleasure.
I'll paint a picture for you. We have what we think works as a brilliant idea for a business process. And we see also there's software that we can end up patenting in the future. Our concern right now is getting companies to discuss with us what we want to present to them, getting a non-disclosure agreement signed, and or should we go the other route and file provisional patents, and as we continue to develop our product in the next several months, do we continue to file additional provisional patents?
Right.
And then say within the first 12 months, provisional patent expiring, put it all together and then file the real deal. And then also the second part of that question would be, if you do not actually go on to file the claims with a provisional patent, does what you file as a provisional patent vanish into thin air? There's no record of it. It's never made public.
So the easy part, I think that once you convert it, I don't think that originally filed provisional is accessible. All right, I should probably check on that, but that's my understanding right now, that it's not accessible. But the rest of your question is a good question, really, because It's a case in which I would say that, yeah, maybe you should file a provisional. One caveat, if you were to file a provisional, make sure that there's claims in there. So at least you've thought about what the invention is, because there's been this project that people worked very hard on, spent a lot of nights, a lot of money went in to fund it, right? There might be several inventions there, so the claims will force and I guess discipline on the thinking as to what the invention is, and then you've got to decide if that's what's most important to advance the company, right? So when you do that, though, you're going to find you're very close to the full cost of a utility patent. But still, you can file a provisional. But that's the one thing I would say with the provisional, right? In this case, that, yeah, you can file that. And maybe, so why else do I kind of, do a 180 and what I've said, don't file provisionals, is because what I'm hearing is that if you're talking to companies and you've spent about getting them interested in these ideas, and I kind of suspect that maybe that they're not rushing to sign the NDAs.
Yeah, they a lot of them don't want to,
Right.
especially
Yeah.
VCs. And
Right, okay.
yeah,
And they've been working in that area, VCs, well, they're not going to be working in that area, but they don't want to be held
just don't
to it.
sign.
Right, you know why? Well, anyway, not to speculate, but I think it's important for you to get some protection, because although I talked about NDAs, these things do come up. It's a great illustration, I think, that it's a situation in which you're not going to get a party to file an NDA. So what do? Talk to them will be open-ended? I wouldn't, right? I would rather maybe in this case err on the side of the provisional, right? To somewhat limit costs, but you know what? You've got rights to the idea.
yeah,
VCs typically talk to a bunch of different companies working in an area, if that's the case, right? Before they look at funding, before they decide who's going to buy whom, whatever. And you don't want maybe things, at least in strategy, I'm not saying they're going to take detailed notes and copy or circuit diagram or something, to filter out into other prospects they might be looking at. So I would look for some protection. And you're right, if you can't get it via an NDA, then look to file a patent pending, right? Some provisional patent application. Yeah.
All right.
With the provisional application, you can probably put a whole bunch of stuff in there that covers several inventions. And when you go to convert it to utility, then you can file those separate inventions. So that's another advantage in this case, I guess, that you can cover many things with one umbrella, right? The risk that I talk about still exists, but it's all trade-offs. So,
thank
yeah,
you very much.
Right. Question?
Sorry that I was a few minutes late.
No problem.
Not sure if you talked about it or not, but would you be able to speak a little bit about what's considered public disclosure? So, is that a conversation over coffee, or is that you standing on the street corner with the
Right. So, good question again. What's a public disclosure? So, let's take the case in which you use a non-disclosure agreement. So, if you're, extreme example, if you're at a trade show and everybody who comes into the booth, you give a non-disclosure agreement, guess what? At the end of the day, when the controversy arises, that non-disclosure is not going to be held to have very much weight, right? On the other hand, right, the flip side of that, if you're having coffee with one person, and it's not like a report or something like that, or maybe you don't have an expectation that this is going to get public, but there is that risk anytime you talk to anyone, then in that case, it won't be held to be a public disclosure, or I should say it's likely not to be held to be a public disclosure. So in general, the more limited the situations and the parties, the number of people in the party that you use the NDA with, the more likely it is to be held not a public disclosure, right?
But so, just to follow up on that, what if there was no NDA? So say that this was sort of in the idea generation process
Right.
years ago. or-
So I think idea generation process years ago, what I would look to argue is that the concept was not complete, right? The idea was being formed, but it wasn't complete. No invention existed, so there wasn't a full invention to disclose, right? It was part of your information gathering process. That's what it seems like to me. Yeah. Question again?
In terms of public disclosure, if you've created a piece of software that people are playing with, but you're not showing the code, or there's an invention that is within a product and the person plays with the product or looks
Right,
at the product in Glossy magazine, but there's no disclosure of what the invention was inside of it, is that still considered public disclosure?
Yeah, another good question. And I think the law in the US differs from that in Canada, right? Because in the US there was actually this very case regarding, I think, a situation with IBM. It was more than 10 years ago. And it was a situation in which they had aspects of the invention. I don't believe it was software, but it was a hardware aspect that was so embedded within the printer. I think it was a printer or something like that, that was being demonstrated. But yet it was held that even though, right, no one had access, it couldn't be reasonably accessed. You couldn't see it, you couldn't feel it, you couldn't touch it. Public disclosure. That's what the law says in the US right now. I think there was a recent case, a very recent case here in Canada that said the opposite. No, it must be accessible, something to that effect, before it counts as a public disclosure. So in the US, much stricter.
Right, I guess if anyone has any other questions, maybe we'll stay around for a couple minutes to answer them.
Absolutely.
I'd like to thank
Yeah,
you for your
absolutely.
very comprehensive and practical.
My pleasure. I enjoyed it. Good questions. Good.